Good afternoon, and welcome to the Quarles and Brady Business Law Training Session titled, Pushing CCPA Compliance Over the Finish Line, New Developments and Best Practices. I'm Kim Mahan, a partner in the Business Law Group here in Chicago. Before we begin today's presentation, we would like to invite you to join us on December 12th for next month's program on the top 10 things we are watching in employment law for 2020. As always, we have a few housekeeping items to review. For CLE credit, for our in-person guests, please fill out the CLE sign-in sheet located at the registration table before you leave today. For our webinar guests, please email the CLE form located at the back of the PDF materials to Jennifer Michalowski, whose contact information is on the form. You can find today's PDF web materials under handouts in the GoToWebinar pop-up box on your screen. If you are listening via webinar and have a question, please type your question into the question box on the upper right side of the screen and press send. The conference host will make sure the speaker receives the message. Also, for our webinar participants, we have muted all phone lines and participants are in a listen-only mode. A survey will be emailed to you after the program. Please be aware that this presentation is being recorded. And now, I'd like to introduce today's speakers. Linda Emery is chair of the firm's Data Privacy and Security Industry team, and she focuses her practice in the areas of information technology, data privacy and security, the Internet of Things, and trademarks. She has experience working with consumer product, service, technology, and communications companies. Linda's experience in data privacy and security allows her to help clients at the international, federal, and state levels, both in regulatory compliance and establishing best practices. Heather Bukta has a transactional practice covering the areas of e-commerce, software, technology, and data privacy, with an additional focus on copyright and trademark prosecution. Specifically, her work focuses on software agreements, IT outsourcing, internet terms and conditions, internet privacy policies, electronic contracting, technology development agreements, copyright licenses, trademark licenses, and trademark prosecution. Heather is a certified information privacy professional through the International Association of Privacy Professionals. And now I will turn it over to Linda.
Thank you for that very detailed and kind introduction, Kim. Appreciate that. What she really meant to say is we're doppelgangers, and we both have a robust practice in technology law for shortcut and for data privacy and security. We came by this honestly. We were in data before data was cool. My background was in the cable industry, and we had a Privacy Act long before HIPAA. So that's where I started, and Heather has been working in this area for 20 years as well. So I want to start out by giving you some good memories of California. Some of you may remember some of these songs. Some of you may not. Hollywood Nights, I Left My Heart in San Francisco, Hollywood. The reason I raise that is because I want to make sure you still have some fond memories of California at the end of this discussion, because I don't think you will have a lot right at the end of this discussion. That is my real value add for this presentation. So you should go home and play all these songs when you're done. All right, so I'm going to let Heather start on the substantive part of this presentation. We'll go from there.
Well, but for the copyright issues, we really should have put together like a playlist.
We wanted to.
But
I was told no.
The IP lawyer in this wouldn't let it happen. Right. So most of you have probably heard one or both of us speak in some form or fashion on data privacy and data security previously. So we're going to do a very quick, brief overview of kind of the prior or current state of affairs, as it were. So in the United States, we do not have a general broad sweeping data privacy and security legislation, at least not to the extent that the European Union has. Typically, you'll hear the US referred to as a sectoral jurisdiction, Healthcare data generally is governed by HIPAA and its state corollaries. Financial data is generally governed by Graham-Leach-Bliley. Educational data governed primarily by FERPA and some of its state corollaries. The point being that sectors of data have regulations specific to them, but not one broad oversweeping law or regulation. Typically, data privacy and security in the United States has been enforced by the Federal Trade Commission pursuant to its authority and jurisdiction under Section 5 of the FTC Act. As a very brief refresher, about 15 years ago, maybe more than that, the Federal Trade Commission came out and said, due to some things that were happening in the industry at the time, that if you are collecting information from a consumer online and you are not providing notice of what you're collecting, that is an unfair trade practice under Section 5 of the FTC Act. They came out a couple of years later and said, if you have a posted privacy notice, but it is incorrect as to what you are collecting, that is a deceptive trade practice under Section 5 of the FTC Act. And their jurisprudence has expanded from there to get into data security issues as well. So that is generally when we talk about what's in place in the United States, that's what we currently have. California did already have some of its own statutes, as a number of other states do. CalOPA dates back to 2004. Basically, all it did was codify some of the best practices with respect to data privacy notices online. If you are collecting information on a website, you had to state what you were collecting, how you were using it, and who you were sharing it with. And you'll see some more information up there generally about what that covered. In 2012, the California Attorney General, being as they are always on the cutting edge of consumer data privacy issues, expressly expanded that to include mobile apps. And that was not something that had been previously contemplated. Kamala Harris at the time sued Delta, I believe it was, for their mobile app privacy practices, and extended this privacy policy obligation into the mobile app space. And then in 2013, the California statute was amended to designate a do not track obligation. There was a big initiative in 2013 at the time to follow triggers, technical triggers that could be embedded within websites about not tracking consumers across space. There never was any kind of technical agreement from the technical IT folks about what those triggers would look like or how they would be programmed or how they would function. So that never really did catch on. But the California statute does say that you have to say whether or not you respond to those do not track notices. Simultaneously with that, again, going all the way back to 2005, California had a shine the light statute. If you are collecting data that you are sharing with a third party for that third party to use for their own marketing purposes, that's something that you have to provide a California resident a right to get information on. It's not widely known, it's not widely used, but it is out there and has been for some period of time.
Question for the audience: has anybody actually received one of these requests under the old statute? Because in the time that we've been working in this area, I don't believe I've seen a single client actually get a request. So it was largely ignored.
Yeah. Well, and theoretically speaking, unless you're actively, data brokers, too strong of a term, but unless you're actively sharing that data for other parties to use for their own marketing purposes, as you noted, it's just not that common. 2016, although this slide doesn't have the date on it, around 2016, we got, California had their own data security requirements. Again, really just codifying what had been done at the broader FTC level. You have to have commercially reasonable and appropriate data security and measures in place, depending upon the nature of the data and the sort of your size and sophistication at the time. Regulators love commercially reasonable and appropriate security measures. Nobody really knows what that means other than they get to pick what it means depending on who you are and what data you have. So that was kind of the current state of affairs. So what has changed? And I will note, Linda had another musical interruption for this.
I did. I wanted to play Welcome to the Hotel California. You can check out, but you can never leave, because that's where we're moving But again, copyright laws prevented that fun.
So what has changed? The California Consumer Privacy Act of 2018 passed last year. You'll see the California Civil Code section that's up there. It's probably not too big of a stretch to say that it is groundbreaking U.S. data privacy legislation. It really takes a different approach to data security or data privacy than we've had in the United States in the past. For those that don't know the backstory, we can get into it after the fact where we don't have time to get into it now. Suffice it to say, it was drafted, debated, and passed in a matter of a week. So you've got groundbreaking U.S. privacy legislation, and they spent a week on it. So it does read like it. The statute itself is difficult to get through and difficult to comprehend. You can tell sections were drafted by different people, and it's not very coherent. We were hoping the regulations that came out at the beginning of October would add some clarification to that. We'll get into it a little bit later. The regulations are not nearly as helpful as we had all hoped they would be. You will hear folks refer to CCPA as a mini GDPR. It's not quite that. It is certainly closer than we've ever had in the United States before, but it's not to the extreme of or to the extent of the full GDPR. GDPR being the European regulation that governs data privacy and security. The focus of CCPA is much more on fundamental consumer data rights as opposed to what we have typically viewed data privacy in the past in the United States. It's not just talking about what needs to be in your online privacy notice. It's not just talking about whether or not you can track consumers across websites. It's not just talking about data security. It is building in some fundamental consumer rights that California residents can exercise. Did you want to go ahead and do this one?
Sure. So the number one question we get when we start helping clients with this process of getting prepared for CCPA is, who, me? Usually the answer is yes, you. It applies in the following situations. It applies to businesses that are for profit, who sell to consumers within the state of California. It only applies if you determine the purpose for collecting the data and the means of using the data or processing the data. This is kind of a European Union concept of, it's often called the data controller. So if you're the one who takes the data in the first instance, really all it's saying. And then you either have $25 million in gross revenues per year, which we have interpreted, because California didn't say, is globally. But California hasn't been clear about that. Or if you collect or buy or share or sell for commercial purposes personal information of 50,000 or more consumers, households, or devices in the state of California, or if you have 50% or more of your revenue in California from selling personal information, which is usually data brokers. So most of our clients fall within the 25 million or the 50,000. What we usually suggest is if you've got 50,000 eyeballs hitting your website, that is enough to bring you within the scope of the statute. Who's excluded? Not-for-profits, with this caveat, and familiar with the number of not-for-profits that have for-profit arms, they would be covered, but the not-for-profit piece would not. HIPAA-covered entities, really HIPAA data, sometimes. Graham Leach Bliley of financial services, sometimes. Auto repair data. The auto dealers clearly, or the auto companies clearly had their fingers through this whole statute. So if you're in that industry, you want to look for some particular exceptions that you will be able to benefit from.
We'll get into some of the additional exclusions as we go along. One of the things we forgot to mention at the outset, if there are questions as we're going along, please do feel free to interrupt us, and we can address those at the time. This is all new stuff. We've all been trying to sort through it at the same time. So please pipe up if there's something. We did get a question. We'll get to that. We'll address that one here when we get to that part of the presentation. So let's talk about the rights that the California statute provides. It does apply to California residents, and it's a bit of a cascading rights matrix if you take a look at it. It's not expressed in the statute and the regs, but certainly the way that the regs approach it, it's implied. There is a right to access specific pieces of personal information that a company may have about you. There is also a right to know the categories of personal information collected, maintained, and sold. There is a right to request deletion, not a right to be deleted, a right to request deletion. We'll get to that in a minute as well. And a right to opt out of the sale of personal information. Sale is a broadly used term. It's not just monetary consideration. It's anything that the other party gets a value from getting your data. So if they're using it for some other internal purpose, basically, it could be considered a sale. And obviously, you can't be in a position where you have to disclose data. And I think this is getting a bit to one of the online questions we've gotten. You can't be in a position where you have to disclose actual pieces of information about somebody to somebody that you don't know who they are. You can't just take a request where somebody says, "Hey, I want to know every bit of information that you have about Linda Emery." How do I know that that's Linda that's actually making that request? So there are thresholds for verification of those requests that are built into the regulations. That verification threshold, depending on how you frame your matrix, goes up or down depending on the sensitivity of the request. So if somebody is asking for specific pieces of information that you have about them, there's a higher threshold. I think the language that the regulation currently uses is you have to verify with a high degree of certainty that it is that individual that is actually requesting that information before you can disclose that data. And so as you look at these cascading rights, the verification processes that you select and the methods that you have to make available for consumers to submit these requests is probably one of the most complex components of the statute. I don't think I'm overstating that.
No, it's very complex.
So how you build out those processes and how you undertake those verification methods is probably what is going to take the most time. You're theoretically not supposed to ask for more information than you already have. So you're left looking at, of the buckets of information I have, how can I verify that this request coming in is actually the person to whom it relates, and what do I do with that? I called it a cascading rights matrix because if you're unable, the way the regs, again, the regs are still in draft form, but the way the regs are currently designed, if you can't meet one of the verification thresholds that's at a higher level, the regs actually say in certain instances, the key example, right to access specific pieces of information. If you can't meet that high degree of certainty that it's that person, then you can actually consider the request just a request for the categories of information, which has the lower degree of threshold for verification. Same with right to deletion and right to opt out of sale. If you can't verify sufficiently that the right to request deletion is from the person to whom that data relates, then you can treat that as a request to opt out of the sale, which actually has no verification requirement. So those are some of the components of the cascading rights. We'll get into this a little bit more. One of the key things, though, from the statute is you can't discriminate against people for accessing the rights. You still have to treat them just as you would every other customer, even if they exercise their rights to delete. That is an eye chart, isn't it? Sorry about that. So we tried to put this in the order of what I would consider the cascade, sort of starting at the top with the statutory citation next to it, to help kind of put that in context. Expansive categories of personal information. Again, for the most part, most of the things that are considered personal information within the statute are things that we would have typically considered personal information. The new exception and the one that is causing the most consternation amongst folks are things like cookies and pixel tags and quote unquote identifiers that theoretically could be anonymous identifiers. And so how do you respond to those? How do you respond to requests for that kind of information? And there are some exclusions within the statute, or at least within the regs. There may be instances where you can't verify who somebody is. And the regs contemplate that and tell you how to deal with that in terms of you respond and say, I'm sorry, we're unable to confirm your identity to meet this request. Obviously, that is a bit of a generalization, and there are nuances to that, but at least based on the regs that we have now, there appears to be some process in place for that to happen. One of the things that you'll see within the statute and the regs, a lot of times when it talks about the notices that you have to have or the information that you have to have, it'll refer to the category that best fits that as set forth in the definition. So that's why we tried to put the categories up here for you. The statute and the regs do seem to be kind of pulling together how the categories that they have come up with. And it'll be interesting to see if those categories end up being somewhat of a standard within the data privacy community. I don't know that we'll get there, but that is perhaps California's goal, to be the standard for data privacy. I think it's just so another point here to contemplate as we look at how the statute expands privacy issues. One of the things that I think we were all surprised to see, the draft regulations at this point, and it's only in the draft regs, it's not in the statute itself, extend all of these privacy obligations to an offline world as well. So we've moved, we started at websites 2012, 2013, we moved to mobile apps. This now seems to be taking us to an offline world. That means everything collected on site, brick and mortar, telephone, mail, event venues, customers, surveys, did you like your purchase today? Theoretically, all of that stuff is going to get pulled in if the regs stay the way that they are. So we'll see if that remains true as we go through the draft reg process. When we look at what the regulations require, there are references in the statute to notices at the point of collection. Certainly I know when Linda and I first looked at this, when we looked at the language of the statute that talked about notices at the point of collection, we all assumed that meant the privacy policy. We all talk about the privacy policy being the disclosure to consumers at the point of collection. The regs do not take that tact. The regs clarify that the notices at the point of collection is a separate thing from your privacy notice. So the way that the regs are drafted, every time you have a point of data collection, it is requiring an additional disclosure of the category of the information you've collected and the business or commercial purpose for which it's used. If in fact that information is sold, then you also need to provide access to the right to opt out of the sale with the do not sell link. The regs do say that if you're collecting that data online, then theoretically providing a link to the privacy policy is sufficient, at least to that section of the privacy policy. Again, we don't know quite how that's going to work yet, even if that does stay in the regs. The point being that it's not just the privacy notice, but there are some technical infrastructure to be built out as well for the notice of that collection.
And it's fair to say that the people who wrote these regulations have no idea how to technically make this happen. And for those of you who are in IT professionals or marketing professionals, this is going to be something you want to watch closely, because think about your website where you're collecting data through pixels and beacons and cookies, and you've got a lot of activity if you're in a consumer-facing website. Imagine how many click-throughs could happen in order to have just-in-time. I can't even imagine having to be a user of one of those websites, because after 14 clicks, you probably never want to go to that customer's website or that website ever again. So I have to believe that the companies who especially are in the consumer products businesses will be pushing hard to drop this concept, because I don't think it's consumer friendly to have that level of impact, but we'll see what happens.
So I guess the takeaway with respect to the notices at the point of collection, I don't know that everyone needs to go call their IT department right now. So you have to start building these. But it is definitely something to keep on the radar screen. I can't remember if we mentioned the draft, the regs that are out there are open for comment until December 6th. And so we'll have a better sense by the end of the year, hopefully at least by the middle of December, it's best case scenario of what we're going to actually look like with respect to some of these obligations.
And if you want to spend the December in California, there are many on-site locations. You can go and talk to the AG's office about why you think those are terrible regs. So feel free to convince your coworkers to go travel with you, because obviously there's a lot to say. Can I just jump in on a couple questions we got that might be helpful at this point? I got one question that says 25 million excludes most small to mid-sized businesses. Also 50,000 consumers is another high bar. It would seem either of these parameters would exclude most small to mid-sized businesses. And I'd say the answer is probably correct with one big caveat, which is it is unclear in the statute, but the way the statute is written, it would appear that the state could take the position that if you are a service provider for a company that meets the requirements, you are covered by the requirements as well. Now, there aren't the same obligations that you have as a service provider than if you are the data controller, let's say, but there are still, if you're in the business of serving larger companies, as a practical matter, this may very well impact you. So, and it's not clear the way that the statute's written whether that was intended or not, but as a practical matter, you're going to have these larger companies coming to you and asking for addendums to your current agreements to make sure you're complying with the requirements of the statute. And there's some safe harbors in the statute for both the service provider and for the company who's collecting the data in the first instance, that if they have contractual protections in place and there's an issue with either their customer or their vendor, that you're protected when you otherwise wouldn't be.
One other, on the 50,000 or more consumer point, the only other thing to keep in mind there is it's 50,000 or more consumers, household devices. Mm-hmm. So it's not just a one and done. So you may say, well, I've only got information from, I've only had 40,000 people access my website. Well, if you also have, IoT data, like my point is that one household could have 50 devices in and of itself, and those each count towards that 50,000 threshold. So it's not, the math is not as straightforward as you would initially think.
It's not. And, if you're the brand new Apple of the world and you've got IoT, if you're collecting IoT data in your products, you've got to assume that you're collecting a lot of data that would probably be over that threshold. This comes up with the next thing you're about to get to, too.
So carve-outs from the right of deletion. Again, it's a right to request deletion. It's not a full right to be forgotten. There are a ton of exclusions within this right to request deletion. The only ones I'm going to focus on are the last three. Quite frankly, the third to the last and the last one, I'm not sure what the difference is. But if you look at those last three collectively, one of the categories, I'll call it, of exclusions is that if you are using the data solely for internal uses that are reasonably aligned with the expectations of the consumer based on their relationship with the business, or only for lawful internal uses, again, compatible with the context in which the consumer provided the personal information, there would seem to be an exclusion as drafted under the statute. So again, some of these exclusions I think are broad enough to drive a bus through, the point being that it's going to require you to take a look at that data. Why do we have it? What are we using it for? And if it in fact is only used in a way that's consistent with how the consumer provided it in the first place, then you may not have a right to, or you may not have an obligation to delete it at the end of the day. So I know one of the questions that we've gotten is addressed to the temporary exclusions that are currently in the B2B world, which do exist. The definition of a consumer as it's defined under the statute is broad. It's any natural human California resident. So that obviously covers people in their consumer lives. It covers people in their professional lives as well. That historically has been one big distinction between the US and the EU with respect to data privacy. The US typically has not considered business data to be protected from a data privacy perspective. As drafted, CCPA does. Given the mayhem that would have caused, they did push through a last round of amendments at the end of the last legislative session that has two temporary exclusions that extend this, that last until 1/1/21. So a 1-year sort of hiatus for the most part on B2B data. So exclusions for employee applicant data, job data, HR data. That kind of data is not subject to the statute until 1/1/21, with the exception of the notice at collection, so the notification at the point you collect the data, and the private right of action, which we'll get into in a little bit if there is a security incident or a breach. The other exclusion for B2B data is for data from quote unquote consumers in their roles as employees, contractors, what have you, in a business capacity. So that B2B data is again excluded until 1/1/21, with the exception of the right to provide the opt-out for selling, and then the non-discrimination obligation. So if you are selling business data in the sort of your marketing context, I guess you could call it, would be an example, then that obligation to provide the right to opt out of the sale of that data will still apply 1/1/20.
So I'm a recovering litigator, and so that we figured it would be a good place for me to jump in on where the legal risks are associated with all these laws as a practical matter. One thing that we didn't see necessarily a focus in the actual statute was on disability rights, but in the regulations, there's very specific language that says that you have to have accessible websites. There was just a recent, the Supreme Court just rejected an appeal of a Ninth Circuit case about the website accessibility. And so right now, the case law in the country, and particularly the Ninth Circuit, is very favorable to plaintiffs' lawyers who want to look at your website and sue you. And I know we've had many, many requests in the last year about assistance and helping with finding consultants to help with the websites, because there have been trolls out there filing lawsuits about website accessibility. Potentially, this is not clear again under the regs, but potentially the AG could pursue a statutory remedy for violation of the this provision. However, what we think is the bigger risk is still plaintiffs' bar and class action suits under the ADA for non-accessible websites. So if you haven't looked at your website lately on this topic, please do, because many, many clients that we have had been approached. It's just the new thing. Probably the thing that we get asked about the most is, okay, what can go wrong? Because I know it's hard to believe, but a lot of times people are like, the statute is impossible. How am I going to comply? You know, is there anything that bad that can happen to me if I don't comply? And the answer is, yeah, kind of. So with regard to the first part, which is the consumers making requests to exercise their rights under the statute, there is a statutory remedy for a violation of that portion of the statute, which is a possible statutory damage of $2,500 for an unintentional violation to $7,500 for an intentional violation. There's nothing in this part of the regulation in the statute that allows for a private right of action. There's nothing that allows for a class action with this caveat. I know a lot of plaintiffs' lawyers are very, very smart and are very, very creative and will somehow use this in some other context as a right to, or as a basis for a suit, imagine. With regard to the data breach, this is more the traditional. If there's a data breach that compromises personal data, or there's unauthorized access to personal data as a result of failure to use reasonable security with regard to that data, and it's scaled based on the level of sensitivity of that data too. So if you're holding healthcare data, or if you're holding information about people's personal preferences or information, their financial information, you're going to be held to a higher standard of data security with regard to that data. And quite frankly, we could give a whole nother presentation just on data security. My opinion is that the data security obligations for many organizations are much more important to follow than even paying attention to some of the privacy issues, because it is those security issues that are leading to these data breaches. So probably in the last week, we've worked on 2 ransomware attacks, and we've worked on, I can't even imagine how many phishing attacks this year. So they're out there, it's happening, and even with the best of intentions, IT departments are still, struggling for resources in most organizations, and they can only do so much. So one of the things we're really trying to push, and I hope this statute will do that as well, is that privacy and security are not just IT's problem, not just legal's problem, not just marketing's problem, it's everybody's problem. So again, under the statute, there is a private right of action, but you have to ask for a cure before you can actually bring the private right of action. Was kind of interesting, and that was highly negotiated as well. And yes, there's a risk of class action here. Common misconceptions. I'll jump through this quickly because you've probably heard this before, but I have had clients ask, I don't have to comply because I don't have a physical presence in California. Wrong. I don't have to comply because I only sell through my website and I'm not in California. Wrong, because if you're not selling into California on your website, I don't know why you have a website, since 1 in every 9 people lives in the state of California in this country, but okay, there might be a few. But to that end, under the statute, if you are, you have to have certain notifications, rights for consumers to seek information. And one way is the 800 number. We'll get into that in a little bit about what you actually should do to get ready. And if you only have a website but not a physical presence in California, you don't have to have an 800 number, though I don't know why you wouldn't want to. The law doesn't apply to me because I don't meet the threshold. I think I just answered that question, yes, but. And then I'm GDPR compliant, so I'm compliant with CCPA. First of all, if any of you tell me that you're completely compliant with GDPR right now, I'm really glad to hear that. I'm glad that your lawyers have told you that, but you might want to double check on that. And then the same with CCPA. The one thing that the two have in common more than anything else is that the data mapping process that you need to take, and we'll go into that in a minute, in order to get compliant with these statutes is really the same for GDPR versus CCPA, with some exceptions related to business right now. So clients that have done mapping for GDPR purposes are further ahead than clients that have not had to do that yet. But that is probably the biggest lift in this process. And we have clients who've done it internally, who have big staffs. We have clients who are using the Big Four. We have clients who are using security vendors. We have clients who are trying to, go on the, hope that nobody comes calling for them. But everybody's doing something. It's just, it's a scalability issue, and we need to talk about that. So depending on the maturity of your organization and the kind of consumer data you have, people are doing very different scope, but they're doing the same path. They're following the same path. So we'll go into that in a minute. I think one of the most important decisions that companies are going to need to make as they go through this process is, and this is my litigator hat now, is do I want to have 2 different policies on my website? Do I have one that just deals with California and one that deals with everybody else? And many of our clients have made the decision, no, they don't want to have 2 policies. And the reasons they usually say that are the more policies I have, the more likely I'm going to make a mistake, and then I've got an FTC issue because my policy doesn't reflect the reality of what I do. Another reason that clients, especially who are consumer facing, don't want to be sending a different message to some consumers than others. They don't want to be saying, oh, if you're in California, you can ask me any question in the world, but if you're in Idaho, forget it. So a lot of our consumer product company kinds of clients have just decided that for purposes of their being customer friendly, they want to do one policy. I do want to caution everybody, though, that we learned this early in law school, that is, if you don't have a legal duty to do something, but you choose to take that on, now you have a breach of contract issue or a negligence issue, because you didn't have to do it, but if you do say you'll do it, then you got to do it right. So now we're in the situation where if you don't have two different policies, you've taken on legal obligations in 49 other states that you didn't have to take on. So that is a challenge, and we're going to keep seeing the laws change in other states, and they're not going to be consistent. So most of our clients are going with the one policy for all residents of all states. However, we do have clients who are not consumer facing that have chosen that that's not where they're headed right now, or they just don't think they're ready to be there yet process-wise, so they're starting with two separate policies. Any questions on that one? To me, that is one of the biggest issues the organization faces. True?
True. All right, so now for the why you guys are really all here today.
Okay, so we're going to, in the next 20 minutes or so. Oh, and there's a couple of more questions you want to take.
Yeah.
Okay,
good.
this one.
Yeah.
What do you actually have to do to get ready? Well, all of you should commend yourselves for being here or on the phone today or in any of the lovely offices we have throughout the country. And we do very much appreciate you taking the time, because we know you're all very busy. But the first thing is to know what's there. Understand what the purpose of the statute was, understand what the statute says, understand what the regulations say, and understand what you have to give consumers. So make sure that you understand what the rights of access are, right? Make sure you understand the rights to deletion, the methods to submit requests, verifications, and so on. You need to really get familiar with this concept of the right to opt out of sale. And we could give a whole seminar just on what is the sale of data under this statute, because most of the clients we work with, their view is, I don't sell my data. I protect my clients' data, and I don't share it with third parties except for service providers. And that's true, but now the way the statute is written, if you're sharing for value consideration, and let's just say outside the service provider context, you can have an issue here. And the place we're seeing it the most is what I'd call affinity relationships, where your company has relationships with other companies that sell products that complement what they're doing. And as a result of that, it makes perfect sense from a marketing standpoint to share that kind of data. That could be considered selling. We are working on trying to understand this better, and we're hoping that this will be clarified as part of the regulation. But that is taken to its extreme. That could be how it's interpreted.
I'm going to jump in here for a minute. We've gotten a question related to that. If a business entity discloses without charging fees customer personal information that they collect to an independent sales rep that the business has engaged in order for the sales rep to use that data to solicit orders for the sale of products from the business entity, so traditional sales rep relationship, could that transfer disclosure be considered a sale of personal information under the CCPA? So first, the question here expressly says without charging fees. That is frankly not totally irrelevant, but it's just to a certain extent irrelevant. The question is rather more, can that sales rep do anything else with that data pursuant to the contract with the business entity? One of the things we'll get to in a minute in terms of some of the other things to consider for steps. If that sales rep can do other stuff with that data, then yes, that could still be considered a sale. It just has to be papered properly. Agree?
Agree. So the right to opt out of sale has a process to it that I won't go into gory detail about. It's in the slide, but you have to be familiar with the process when you get these requests as well. Then the next thing we're doing is working with clients on preparing communications to respond to a request. So we're working on templates that are pretty straightforward because we're supposed to be, remember, consumer friendly here, that basically acknowledges receipt of the request, maybe goes back and asks for more information, sends out communications about verification, and then responds to those requests. The marketing teams that I've been working with with some of you do an excellent job at this, much better first drafts than most lawyers would draft because they actually write as if the consumer's reading it. So what we've been doing is the clients have generally provided that to us, and then we look at it to make sure that it's got the legal support that it needs. But what we've found is that is a much better, the final product is much better if the clients are involved in that. And the marketing teams and the IT teams in this process are just absolutely essential. So if you're just working in legal, you are working in a vacuum. You've got to engage those two groups of people. For one thing, they understand cookies and web beacons and Google Analytics far better than any lawyer I've ever met. Then the next thing you really need to do is data mapping, and we talked about that a little bit. What you're really required to do is, I call it the bouncing ball of data. So you have to figure out from the moment a consumer engages with your company, and remember, this is business. This is whether it's at the Packers game, whether it's at, it's the website, whether it's a phone call, whatever that process is, you have to figure out what that source is, where the data came from. You have to figure out, you have to be able to identify exactly what category of those 11 categories it falls into. You have to figure out exactly what specific pieces of information, name, rank, serial number. You have to be able to tell the customer who you're sharing with that with, and you have to say why you're collecting it. And that, when we get to the privacy policy, that is going to have to be in your privacy policy. And if you want to spend time, you really should spend a little time with your marketing teams and your IT teams together, watching that ball bounce, because you'd be surprised how many of those balls are bouncing through your organization that you don't even realize. So that is critical. They have to be at the table. Customer service has to be at the table because they're the ones getting the phone calls. HR needs to be at the table because in a year, this is going to be their problem too. And so we've seen a plethora of ways, as we mentioned earlier, of how companies are doing this. Homegrown, consultants, software tools are big right now. You can go on the web and find 500 vendors who will sell you a software tool that will make you CCPA compliant tomorrow. But then when you start asking them, well, they're not lawyers and they don't. So
one of the CISOs I work with calls it magic fairy dust. Magic fairy dust software tool. They just go in and automatically it all happens.
Yeah, nothing ever really works like that with software, but software can be a very helpful tool in this process. So then the next thing you're going to need to do is update your privacy notice. We have been working, some of our team is here today. We have a very wonderful team of lawyers who spend most, if not all of their time on data privacy issues. And right now they're spending a lot of time writing California, helping clients through this process. And we've been drafting privacy notices, and it is a bear to do. You can't do it until you've done the mapping because you can't possibly show where all the balls are going in your privacy policy if you haven't done that mapping. But you're going to have to literally show in boxes, this is the data, this is where I got it from, this is why I took it. It's sort of like having a detailed homework assignment of everything that you do with data. And it is, again, the statute's still not clear on exactly what has to be in it, but the most important things are you have to have the rights language to say that the customer has certain rights that they can exercise. You may or may not need that button, the opt-out button. You need to be able to say if something's sold. And of course, the regulations say it has to be very readable and consumer friendly as well. So the drafts we're creating are long. We're going to have to figure out once we have the content there, how to make it more consumer friendly. I think that's what marketing people do really well. So again, this takes a village. This is no longer just write a privacy policy and stick it on the website. And also, you are required under the California law to update your website privacy policy every year from here on out. So, you know, that's just going to be on your ongoing compliance requirement. And then, you ready?
Yeah.
Okay.
So then step 5, in being ready to respond to those requests. Linda mentioned some of the templates and getting those template response forms ready. Training is a critical issue. It's required not only by the statute, but by the regulations. Obviously, it would be the best practice anyway, but the statutes actually say the people answering these requests have to be trained in terms of what are the rights and how can they respond and how do they respond? How do they verify that it's the right person? And overall, stressing the importance of data privacy and data security to the organization. It's going to reduce your risk overall in the long term, and having these training processes in place sets the groundwork for that just for that culture within the organization, and then documenting that process. What are you doing, and what are the triggers for verification so that you have the ability to verify your compliance. Reviewing your service providers and the contracts that you have in place with them. It's not only service providers that house your data, so hosting vendors, data hosts and things of that, any vendor that accesses your data. I've been taking an expansive view of any service provider that processes your data in the EU sense, stores it, manipulates it, sees it, so on and so forth. Take a look at those contracts. Rank them, which ones are the most important, which ones are the biggest vendors, which ones have the most sensitive data, and start reviewing them and potentially putting amendments in place to make sure that there is strict language that prevents them from using your data in any other way, shape, or form that's going to pull them into that sale category, as opposed to just a straight service provider providing a business operational function for you. I think that was it. Step 7 for incident response and data security. Again, this is something that should be part of your best practices anyway from an overall data security and privacy program. The reason it's important here is when you look at the text of the private right of action, that private right of action kicks in if there is a security incident that results in the exfiltration of data due to, as we said earlier, negligence of failure to maintain reasonable security. So if you can get ahead of that on the front end and reduce the risk that you're going to have those kinds of incidents, the private right of action also only kicks in if the data is unredacted and not encrypted. So if you can redact and encrypt as much as you can, again, that reduces the risk that you're going to run into that private right of action. Following best practices, and we'll talk a little bit more. It's not until step 10, you have to wait patiently. In terms of best practices, as we look at where privacy programs are going to go, there are absolutely ongoing governance and compliance. This is no longer something that we can all just kind of pay attention to in our off time. This is going to become a core compliance issue. Ongoing maintenance of your data map. Data map is not something that can be one and done. It's going to change inevitably as soon as you figure out where that bouncing ball is. Marketing is going to want a new tool, or IT is going to need a new vendor, and that data is going to be going elsewhere. That is a document that is going to be constantly in flux. And so doing ongoing privacy impact assessments as you look at new vendors, as you look at new processes, as you look at new products, how does that change? How does that impact your privacy program? What risks does it create? What additional things need to be taken into account as you insert something new into the process or as you remove something from the process? And then creating that documentation to show your compliance across the board. Why did you make a decision that that vendor was a service provider and not a third party to whom you were selling data? And how did you document that to confirm that you've got the paperwork to back it up? Step 9, you've got to be flexible. As we said, the regulations have just issued. Comment period closes December 6th. Again, My hope is that we'll have final regulations by mid-December. We'll see if that continues to hold true or not. The statute does go into effect 1/1/20. Technically, the AG can't enforce it until 6 months after the final regulations are issued, or July 1st of 2020, whichever is earlier. I guess whichever is earlier. And so keeping an eye on what the AG is doing in terms of providing some further guidance and clarification. The California AG's website is actually very helpful, and they have a lot of public notices and news feeds that you can subscribe to get updates. And keep an eye out for other states. Other states are active in this area, and there's my fun chart for the day. Maine and Nevada just had 2 statutes that went into effect. The scope of them is actually pretty limited, and so not nearly to the impact of California, but you can see other states, courtesy of IAPP here, where legislation is either pending, is being talked about, debated, whether there are committees looking at it, or other organizations. My guess is that Washington, Illinois, and New York are going to be the first 3. I think New York's probably closer than most others. And so definitely keep an eye on those. What we're seeing from some of the draft legislation that's out there is that these other states, particularly New York, is very consistent with what California is doing. Now they are taking a much more thorough and measured approach to it in terms of what they have in their legislation, but it is entirely possible that we are going to end up with potentially 50 different data privacy programs out there that have to coexist. There's always the possibility for federal legislation. I don't hold any hope of that anytime in the near future.
No.
And there's actually some talk that the states, particularly the senators, as each of their states come out with their own program, they are actually going to be disincentivized to promote anything at the federal level, to promote their state's program over anything else. But how do you even approach all of this with all of these other states out there and looking to do similar things? I mean, best practices, get a solid privacy program in place now. Again, I don't recommend that anybody in this room ever say they are CCPA compliant or GDPR compliant. These are ongoing compliance processes. Get a solid program in place now. Transparency, notices, figure out what you're doing and document it. Then as these additional states start to come online, you tweak that standard potentially for the lowest common denominator, right? To get something that makes sense, taking into account, well, I don't really do business in New York, so I'm depending on how the New York statute ends up passing, but you can take those measured approaches in terms of the risk-based analysis of this is really important to me in this state, so this is what I'm going to change my privacy program across the board to look like. So, and with that, questions?
I want to raise one more thing too. For those of you who are sitting here or online and think, I haven't even started, oh my God, take a deep breath, because we had the same exact situation with GDPR. We got many calls months after it went into effect saying, do I need to do something with that? So do not be embarrassed. Many clients have had that situation, and that's what we're here for. So even if you feel like you're getting a late start, we can help you triage what it is that you should really be focused on the most, so we can get some stuff out there to show the world that you're complying or trying to comply, and then we can help you get the larger governance piece in place after we've sort of triaged the immediate crisis. So there's no cutting corners here, but there are ways that we can help you get ready in an efficient way, understanding that we're never going to have a perfect situation, but we understand with our clients that you are not looking to spend $1 million with law firms and consultants trying to get compliant. And I assure you there are consultants and others who will easily put a bill in front of you for something like that. So there are ways to be practical about this, and we're happy to help in any way that we can in that regard. So I just really want to emphasize scalability in this process. obviously, if you are a data broker, you have concerns that are, very different than if you're a mom and pop who rarely steps foot in the state of California.
Well, and I suppose that is another point to mention. Everything that we've talked about today is based on sort of the regular run-of-the-mill kind of business. If you are a data broker, there are additional obligations for you under the statute, registration obligations, so on and so forth. So if you are a data broker, if you're actually selling data to third parties for them to use in some other capacity, then we should talk later. But that was not possible to fit in 60 minutes.
Right.
So,
right.
Any additional questions?
Well, we're happy to take any questions offline as well, so feel free to drop us an email. We kind of live to answer questions about this. I don't know what that says about us, but we just, well, okay, there's some other things in our lives, but we enjoy this, and we actually sit around, we actually sit around and read the statute together and talk about it. So yes, we're kind of data nerds, but we're happy to help in any way which we can. So thank you all for the time. Really a pleasure to have the opportunity to speak with you all.
Okay. And I know we have, if there aren't any other questions, I know you have one more question as well. So we have one more question coming. We did get a question about how are CRAs impacted. I assume that means consumer rights of action. This particular question says, we collect personal data only with consumer consent for a permissible business purpose and only provide the information to the end user that the consumer has authorized. In that context, all of your consumer rights are still going to apply. So you may provide disclosures at the point where you've collected that data from the consumer about what you're collecting and who you're going to be sharing.
CRAs.
CRAs.
Yes. Consumer reporting agencies.
Oh, consumer reporting agencies. Got it. Consumer reporting, thank you for that clarification. Consumer reporting agencies and looking at things from that perspective, they are actually one of the categories excluded in terms of those kinds of businesses. So
yeah, one of the exceptions I should have put on the slide was there's an exclusion related to those who report under the Fair Credit Reporting Act. Again, they're kind of like the situation with HIPAA and Graham-Leach, where there may be some obligations there as well, but it's generally carved out of the statute. So thank you for that question, and thank you for the clarification.
Okay, I'm just going to read the last one because it was a little kind of long. You discussed whether a data controller is subject to CCPA. What about a business which contracts with entities to collect personal information directly from the business's customers? Therefore, the business is not passing along any information, any personal information to these entities. Would such businesses, hold on one second, sorry. Would such businesses be subject to CCPA if these entities share the collected information with the businesses?
So it sounds like perhaps it's an instance where the capital B business that is subject to CCPA has actually engaged a service provider to collect the information on their behalf. And if that is in fact the case, the service provider is still a service provider and the business is still the capital B business. It's just the nature of the service that service provider is engaging in is actually the primary collection of the data from the consumer on behalf of the business. Again, as long as that data is limited to as long as the service provider can't do anything else with that data other than provide it to the business for the business's internal operational purposes, that should still be a service provider relationship, if I'm understanding the question.
Yeah, that happens a lot with call centers, for example. Most companies of a certain size have a call center, and they're often outsourced. And so that is their purpose, is they're collecting information to assist consumers or assist business customers.
And then finally, what is the website to see the draft regs?
The website to see the draft regs, the draft regs are currently on the California Attorney General's website.
It's oag.gov, I believe. Is it caoag.gov?
oag.ca. CCPA.gov, I believe is the website.
So if you just Google, if you use the Googles and you look for California Attorney General regulations, there are also some conformed copies of the statute because there are a lot of amendments at the very last minute that you can find online that are also helpful, because if you try to figure it out by yourself, you'll be wasting an awful lot of time. That some law firms have spent lots of resources putting that out there for you. So feel free to use those resources.
Yeah, it's oag.ca.gov. And if you go to that website, you will see there's information about California and its privacy initiatives. And like I said, there is a link there that you can sign up to get automated alerts for the latest updates.
And we are planning on sending out some additional information next week, just some general cheat sheets. And then we are also looking at writing some articles about how does this impact specific industries, so manufacturing, financial services, healthcare, education. So if anybody's interested in those, drop us an email and we can make sure you get a copy of that as well.
Otherwise,
that's it.
Thank you.
Well, thank you,
for
everybody.
attending.
Enjoy the rest of your day. Take care, whether you're in Naples, where it's 85, or Milwaukee, where it's 14. Take care.